Right, ebusion be like video no share dia mobi fufuro na ono nso anya bi etumi ahwe. Na ene ubepiem ewo Ghana, His Excellency John Dramani Mahama ebe Ghana mampanyin ene Chief Justice Madam Ketru Tokonu oyini free ho ane no ode obi fufuro eye bafu boni ena aba ono ena ehwe atenten ne de keka ho so. Na ene ade bi ekoso o man Ghana mu a dodo na hu se ade a entwa yie kura isanse mampanyin eba ye ene wohwa ni akwakochiri asimesi wohwa ni akochiri obintin ene chema untumi na minu ekase gusu a odi court akoniaba gifty oware mensa ne de ene namu anse ya kofi nkansa nsoso de ene nam kwanchen abutre kamo ne wona ekeka ho na eno enna mranimfo bi acheche nsemu kwan a Ghana atwentenie yede efa so no judicial system no krampo no kwan a management ekoso no niam bi wo ho a se impanyifo anhwe na omo ankasem na yensi gina ye papa a ebetimi akwakofo hawo de abre oman na aban system bi ba na aban fufuro nso ba na akwakoyese revenge bi na ekoso oman mu anhwe ya eye nipa ena edi bebre oye maimu a omankasa bebre afa ho amepese yebegibre yakwakutie nsemu a omode atudwa no na yenso ya kirekire yadwen edi afa ho.
That's true. Take us through because you say Mamia Grada last year when we read the Criminal Offences Act section 137 talks about charlatanic advertisement. You were charged of charlatanic advertisement, and other hands, 131 so talks about the false pretense and defraud. Say a false pretense and defraud. Now, the charlatanic advertisement is an offense. It is not a crime, but false pretense and defraud is a crime. So, based on this, and you jail 15 years. But the false pretense and defraud, classified as a second degree felony, and then the second degree felony is a 15 years. So how did you do it? How did you do it? It will reduce you at about 1 year. So take us through. What did the judge say?
All right, me no be my meda was super. The attorney said the kind no afie twem no ana ya mama Patricia Sidwa aya Accra Circuit Court 10. A day judgment by concerning case and near dinner court or bear 4 years. You're charging her with 4 counts of fraud by false pretenses under section 131 of the Criminal Offences Act at 29. Yeah. And you're charging her with 1 count of charlatanic advertisement. If we are in the court no convicting on 1 count of charlatanic advertisement and 2 counts of fraud by false pretenses. Anna equity on the count 4 and count 5 a year fraud by false pretenses. Now, since Ghana for Bibiano any anchor JDC war a year High Court then say we circuit court judgment no or come and to Ghana for assume Ghana for Adrian Yakumuse over offense a fraud no. Minimum punishment and random no 10 years and a maximum punishment 25 years. Yeah. Because Rano say minimum near 10 years, now maximum near 25 years no. I don't know my 15 years. And it's also my circuit court judge no kind. And no na to Ghana for be na no akoma so a ebinum kra ibusa say na by the send yet me so from 15 years to 1 year for an offense minimum punishment 10 years. To start with no asama circuit court judge ne kan no and hobrase mana enyina emraso o hwe section 131 no a ekreti aye offense no a ama any minimum punishment no started from 0 to 25. It asama circuit court judge ne kan na ato Ghana fu bebre na akoma so no de kan circuit court no sabi otin e wo honom eti ye call aye appeal no ye call da nanke ye hwese conviction in Accra no ka yen setting aside the entire case say conviction yen setting aside ne say on say ukọ mremu a na say ukọ court na yedi asem na yedi no yegina mraso na yedi ni wia ya sanso agina mraso abufo na yegina mraso atwemaso asem ne koso no prosecution change one charges no 2 times Now each time I'm change your charge sheet, and just be a Robin the charge sheet is number correct. No, they change the substance of their case. Last time I'm changing your charge sheet, now we were call about 75% of their witnesses. Ama exhibit ni be na no mo da begum, ana mo change or mo charge sheet. Oh, your criminal cases so charge sheet no, and on the basis, and not quite the foundation or build it was some of the other. To the moment that Obe withdraw such charge sheet, Adebia will build it on it up to the time I will withdraw false on its knees. That is how the new charge sheet, the new charge sheet in the back. As I say, as I fret as a phone mobile back. Now witness statements now the bar, you're reintroducing. Near sign to 2 man bill. Sound your money in ano, anko so. It's not a cassa, I dance and the crampa, ye so, they dare boom my menophone, and remu pad dear. The shock when first with dear some dear and kinim. Now so sure, appeals court near and Adrian say, we're not quite criminal case. So it will not turn on technicalities. It will pay too much attention to the technical argument and making. Secondly, Osha try to say call now, so the medical can you count 4 and you count 5 for one man and court no acquitting. Oh, your criminal case, Mbrana judge say prosecution you in the case, only the friend of prima facie case determination. Me who's a prosecutioner or bo quaduno or the adansia kakrebia ba edimu and sana wakase won't defendants no and as a accused person be with defense. To say omu case no na sa adansia bia ni ho dia and who he has a better accused person say in the defense. Osha judgment as circuit court no ebekanya just say be amelo any in American or say I have acquitted and discharged the accused person on count 4 and count 5. The reason is the prosecution did not lead any evidence. A horn in the agent say now the prosecution no and lead the evidence be there. And on what basis now can say you open a defense? Now after say you open a defense, no back with that means that were you seeking us to self-incriminate? Because in criminal trial, when say depend on father and say be a madia, and the back say ye me in defense no, na uni na so be a womrem. It is what me yes adia, and the whole trial was contaminated because any papa na udi asem no, oji evidence, and the court of appeal be a judges mensa. It is also any power you to me na kukudru catch a year accused person say on for the defense mra. Wabra wa unim say father and say be am right there. Then that you know is an unlawful act. And that is an affront on the Constitution. The share arguments now they are advancing now they were technical in nature, but judge no is to say or not a criminal case. So he understood the technical argument we are advancing, but he would not allow the case to turn on technicalities. It will share your submissions make your final address file now about 48 pages, but they dedicate over 40 pages on pointing to the records. Why we think the trial was so flawed. Osha witnesses from Munina because no matter your charge sheet, they were not seen to have taken an oath. A man may take oath to be a Tisobisuba court no be there dancing, no one take oath. Untimin fa hotosono and to so na umwane for compared with Obi or not take oath. Sana money in a kind. To say a shy, and say, Osha the enormous and answer the enormity of the procedural flaws ne what trial anymore. Judge Ninim Demon, who said, Psycho might be a 2 years crack, a better federal appeal. But Opesa or She, Professor offended the sensibility of Ghanaians. The Senate said there, let me uphold the conviction, but reduce the sentence substantially. A bio Osha sentencing a regime noir. Sir, Udi case in we na bois independent for there was sentencing hearing. Prosecution Bema a plea over make prayer. No watch what address to say here now you know who say o man stiffer punishment. Obetu adwene see the friend aggravating factors so. We are not defense so I make a prayer in mitigation. Also bet the judge no say say or ma accused person a lower punishment. Ranisha judge ne say o hwe aggravating factors no. Any mitigating factors are yemi no nyina yakam na ogina so na the sentence are be fitting na the ma. Record munum edam pefe say judge no share only the aggravating factors. And some prosecution can ujina so or the punish your mammy. The mitigating factors are yes, so you can do Obunani ego so share your constitution article 14.6 no. We're making it very clear. Says judge now dear some now what the punishment bar. Senipana over punishment no. So what did days be or custody more? Sad number of days now wedding. As I say, consider and son the punishment number. That is a mandatory constitutional imperative. All judge to me, hey, ignore it. And I don't know who to sentencing guidelines also. The judge no and fan adrian question say sentencing guideline no. What the to a parent act no ho and no any papa. How share yen laws a hierarchy of laws. Constitution in the we are know about the statute. It is a statute in the case someone untimi fa a mere guideline and may regulate asama parent act naka. Parent act naka sano wa ma any minimum punishment. But over sentencing regime munwa and na ma guidelines. The attorney say parent act and say ubetima punish nipa no up to 25 years. Question is then a bit much say me man nipa no 2 years. And I'm a man 5 years, and I'm a man 10 years. And on that sentencing guideline, never should say, who could do some the first necessary option, the value, the amount involved. Amount involved. The kind of work fraud in the necessary option. We are not by second level. Second level is over share. Sikano. Is it between 0 to 500 penalty units? So between 0 to 500 penalty units is there. We get a non-custodial sentence. A cast of 500 penalty unit, 500 penalty unit is 6,000 cedis. It is a fraud, no? Up to 6,000 Ghana cedis. In the Panocrabi to Major Manakufi, no fine, and that's why I sign bond. And I be and funding question prison. That is if the amount involved is less than 6,000 Ghana cedis. Oko level 2, no, actually, the amount in there about 6,000 Ghana cedis. But there are other aggravating factors there. And obey to me, I'm up to 2 years.
Okay, save that because of the time factor. So, what was the money involved?
The money involved, 500 Ghana cedis. And today, be a mechanic. Oh, the any aggravating fee as same way.
It was a 500 Ghana cedis. So, or follow within level bear.
Level 1. Level 1. Level 1 is up to 6,000.
Okay, so level 1, no, the sentencing guideline, Emma say.
Non-custodial. Okay.
Okay. Now, because of the time factor, my member tell Nenya Kwaikona, my other panel number. Now, let's watch this. When you read the Ghana Court Act 1993, no, it talks also Court of Appeal Rules 1997. That's a CI 19. When you read the appealer, a chance say obi enyasem. Nese be ye jelu na say ya pass ruling near the court no ho ne tender in any other evidence meaning say bia me show me ignorance and no correct me say ho ne tender in new evidence bia but you made us to understand say witness na enam so me jeli o client no court of appeal na inconsistency bi aba o masem Adentin yan so the first one ye dijelu no since the appeal per the ICI no say we just go there for rehearing not say yes akwa all this stuff Jamaica no so rehearing why didn't we base on what the circuit court no issue to jeli maame no so that ye babonko na imran channel sai ekoke kansem bia ase na ene the first one no ebebra.
Okay, the attorney says CI 19, no. CI no regulate civil procedure. Appeals regulate pertaining to civil procedure. And we no any civil case, we a criminal case. They do BMCI no a court of appeal. CI no share say what the civil case court of appeal and near my cost one mo kwa befa so aye no. And na CI 19 the eka. Oba the criminal case. And moreover no the high court. On the back criminal case, and she share first with the Act 30 and only need CI 19. The CI 19 moon is a and yet Juma a year Act 30 and it doesn't apply when we're dealing with criminal matters.
Okay.
The two be the case appeal is by way of rehearing. The attorney said, docket now a war try court one. And then man I call so in and yes, how the bread judge for bill. On the so shrink cat and winning bill. On the so for. So I said, no, just say, I dance here, a course so a friend is a lower court on mono, untimate no one can. And some of the course winning in a day breno, or also started afresh from charge sheet no about written statements, about submissions, about the course when you know, no, so making an independent conclusion.
That's what I'm saying. That's what I'm saying. That look, we say that it's a rehearing. You wouldn't be allowed to tender in any other evidence. So what I'm asking is, Emrantia no a obu go first one a day a jelly or client no. How come that at that particular time a appeals court no almost sakoke kansem bia judge na mfa the circuit court to their normal kase okay the oma kano ye betimi akase bi evidence so any evidence a new thing a new material no de be kan but in the appeals court no ye mfa sad ne kan no one based on the old a ruling no answer anu ankasa farmer ruling na o based on the inconsistency that na branch na keke kana or the omo de be kan no.
Okay, the court of a high court one. Yeah, friend new witnesses be the witness be who are a friend or high court. A yan some court so circuit court of one and another judge in the castle. O share a dance here by circuit court of one. What did they dance for police for you among none? Now inconsistencies be brave womb. And now share the answer the choir now. Now inconsistencies be brave womb. But try judge and not attempt one banner. Or focus on the inconsistency why you did. But prosecution there one can say. Now, sir, by now, circuit court no done a gino. And no cabisi as I'm to say, judge no can say, you improve your innocent because Sanka of focus so. What inconsistency of police for no, I don't see anymore. Kobun say police for some instances so. It's a cow invite a cry say in fire, I dance emra. That's another judge the sort. Say police for some of the buy because the Ghana phone him say, Eddie can police for no catch the Ghana for say, my many money doubling exercise. Okay. Then so dance for no buy the pimo no can plane. Some mamma no one money doubling beer, one can be beer so money doubling. The police one who saw myself na come about home. And almost a charge sheet. No, we use allegation a film. Back by an Eddie kind was it my manager in 900. I feel so much in the 500. I feel so much in the 300. And nipper back up on one issue. As you were saying, what's a 900?
That is a court of appeal. I know a court of appeal.
No, that I know a circuit court. One in our
circuit court. Oh, okay.
Circuit court. One in our.
Okay. So the inconsistency did happen over the circuit court. Not the
circuit court.
Oh, I see. I get it. I get
it. That court, no, I say inconsistency and war prosecution for an assembly. Saka to what drink course. Kabos or months, some insist
so. Okay.
It's a count can't cry, say a crime may be a defense.
Okay.
But auto judgment is so banner. What can I say? Yes, I can insist so. Now, so prosecution for not some instances in the one more who are cry. Now, such ban circuit court judge no, a done a dino. And the Maya Jimmy says, understand, and the mamma, okay, so proving innocence. Because I could focus on the inconsistencies in the prosecution's case. Can you crack conference and fire dancer? Like I said, Kuboku.
All right, thank you very much. But my maybe so yeah, Sana Wako. The Afro Barometer a year about last year. Say about 85% of Ghanaians don't trust the judicial system. Would you, as a legally, or father say, what do you want to say? What's your take on this?
I say we're not quite perception. The perception there, any personal experience or judicial in our encounter, and on a toda way there, or bidding one dance. Anna and Pimpin is a toda media no small role to play. To say judgment, I can watch me say, no bit man will be crying on your but and can kind 45-page judgment and some nasi. But to beat me actually seminal and sana basreso. Sans some in animals and really pepping mutim. That's what beat baby and I drank when they say, appeals judge now, or no, the right thing in the woman, or no woman, the wrong thing. Meanwhile, 15 years, I'm a minute the mine. But you much time say, at 29, I'm my name minimum threshold. Some from so as circuit court judge in a year, high court in the correct. None woman by yet at the tongue of 40 Mr. Papa. It's a perception of the age, any pabian and experience when ya, no one pine the air boss in Nano, Yababwa, not judiciary, no, it's major and also. Because the best man criticize judiciary in Nancy Samoa, the Juan and the Beco. So, Juan and the Beco.
More corner now, say that day, no, that particular day, no, Mubedin Kunim, I say a beba 1 year, no, now was I know.
Oh, as a lawyer there, I have confidence in my case. Okay. But as you say, a beba 1 year, a beba 10 years, a beba 25 years, and a beba some Nagun Kwadi, a judge and a Kwanin. But the brother judge in a reading judgment in 1850, because we did judgment now, he kept dismissing our grounds or dismiss a ground saying I could still do sentence in Hormone and Sana or near Eba Bayadri. I had confidence in my case, but until such a judgment was read, I didn't know what the judge decision would be.
Lawyer Darcy Jamo Akwana, Mammy so as some way say, Debiania do client no coquota, no acatanity, no acatanity. Na that day Nankasana unya 1 year no, na sa day na yen catanity. Then call for suspect say 7 previous so when you were ferry, make Casasana or nobody can you sumasi a dada, it's more conamun gebesi. That is the reason why that particular day Nankasano we need to know every so. We are the infinity.
But as the question I'm going to say, judge not in sentence and also from 15 years at about 1 year. Now, any public margin almost said, you may be about 1 year, no dear. And the name was as a man, 15 years in a man, or you may be 15 years in a man. You see, the first thing they say, Mamma, no, so back, no one brand to be a friend appear biblical. Our court case. A probably can be catch a Ghana for you now, sir. Mamma, no, wash it. The color you know, to Bejina court, judge no, you know, where who enemy. And the color Nasa cry, sans a mere sure so would be. So that's it. And sad day, no, there, mamma, the last day in court. In fact, in the case of only I can only give to Casey, ya can we, only a public case, I can we. It's after sad date, no. Mamma be more. This was trying to tell me. It is after Saturday, I court no, and you will be a man 15 years, sir. King who are glad our one team beam, because it's 15 years, no, will be baby. It is so weird, or ba, near whom is so a coquire. They can't afford a cat say, Mammy, you call a cocoy, and I go call name of you to. So that's it. It's another coin a last day, no, a person Ghana for you now, Mushibi, the color nice ashen. Any, and I sent it, sir. It's necessary be a baby answer. Now, I'm say, Mammy must question me. Oh, said there be a bus no that I didn't look at anymore, and go for home how. They know be no can say, and go for home, they know can say, and you're glad I cried in the backwards. Such as I'm not TV, sir. Aye. And to nip any papa or Catan anymore your home how. One Catan and Mrs. Sawyer, a deity and the Catan, a deity and the Catan. The name of the Catan, sir, America says, oh, a prisoner, all right. Who now is a to me to a picture of Abraham McQueen. No credit. Some person me to a picture of Mamma McQueen. So that's it. But on a baby or a bank of bagunes, police wagon in 20 million prevent 2 beer on Peninsula trying the picture. When this are known to bet my answer back at Tano. All right, but last day, no, so now a bank of bagunes out. And so you need and I met him say last day, no, the never second for who the color now. I probably like a back up. So I should call an ash. You try the pictures, moving and with one dance here. So I show so on she or no one so that's intended BBI. Yo, yet time now so now only Empress gifted, you know, Empress gifted a meme sister no. So only Empress gifted, you know, also my career, aqua say, mo career say. Empress gifted there no mamma nanas, namena only kuninasi, or much less o me a Christopher, or Mother Christus Swedi. A 7 by no, Ebo Piniomo, at the chopper coy, or Musum, or mammy and Trinity until the tennis say. Nina no esi yapata wo ya apologize ti asem bia ni oni gift asem na chibiem sanso so no na pepper beka so so ya kan wi a eno so asem dui aba ti asem bia ni agada ho bi enti da be no obebe fie no roughly it's a very difficult question to answer, but the earliest time obetimi aba the 3rd of March. 3rd of March. Yes, all of that is being equal. Enti ya okọ jiro. Oh, Metacoson. Yes. All right. Yeah, but that's CP. Yeah, Mr. on come on. Ghana for a best remo. Minim said, Abana, ye Ghana for Bibi Madrimuna. But I am a custom with the mommy a grad dancing chain. Now, I'm finna papophobia, Meshaho. Say a custom Mr. Wusu, Wabubi, Afaswaj in the same Sika 500 Ghana cedis. I saw you in Senate, said the man. Siki woman in I 500. Na ma me no akoye obi a sabi wate say asukiri otohope na ntachia a de afo no ho yenim say odi domanim enti ba bia wogina ni no so odada obi gine nsem 500 na yema na so twen 1 year na je di say punitive enough eti yes bia mama yemfa nche na ye move on as a nation wadaroma
All right, thank you very much. Lawyer Richard Asari Bafo, a council edema, my evangelist Asiedua, aka Nana Agrada, lawyer Richard Asari Bafo, our Asamani law consult. So, all on the way any of the yesterday case. So, we have 3 legalists with us. We have a lawyer Amankwa Hinijan, private legal practitioner, broadcaster, and a political analyst with us today. And we have a lawyer Edu Dakon, is also a private legal practitioner, such a brilliant person. And also lawyer Joanna Ousu, a council, the board of trustees, a National Cathedral. Gentlemen, thank you very much. So let me start from lawyer Joanna. Lawyer, so you listen to the man. Utien ye pa say ye de no to so anche na wo bai utien ye, but there's one thing that na eye bitrimu na kakra uhwe Ghana, we don't have sentencing act in the country, but we have sentencing guidelines according to you know say honum. But what I know is the false pretense and defraud no a second degree felony, and the second degree felony is becoming like a standard say law worldwide. Our bagara has here we read a criminal code now. Your criminal code no act 29 no MTS say the false pretense and defraud section 131 no the punishment no since a second degree felony no from minimum should be 10 years and the maximum is 25 years. So if say you're jailing the penalty 15 years, let's say ebia ye pese ye ba ye reduce na, why do we have to go below 10 years? Because I said the minimum should be 10 years. But according to normal say new guidelines for Swaba, if you know about the new guidelines now, obetimini ya chena wa chechire mu na ye ne ayantia se ne yetimi atiase yi.
Me I said they've been reading new guidelines now, but
Okay.
by taking from the lawyer no representing I mean Kano, by explaining into detail and their course. So, while explaining into details what actually went on, how the woman was convicted and how they went on appeal and the rest of it. Now he was very detailed about the circumstances under which the woman was actually jailed and convicted and then sentenced. Say it did not actually follow the rules for conviction and then for sentencing. Now, no maybe cause for war. A judge need the assembly winners or a conviction, not so best sentence. And some folk who say it is not just the law, because the law says the law says. It is not only the law that the judge applies at that time, or the public policy capital. Public policy is what is accepted on the streets. And that your jury system now, your jurors on better 12 of them, no, so I'm on your lawyer for. And so you're guilty or not guilty. It is bringing what happens on the street into the law to determine what the punishment should be. Now, from what he says, it's kind of 500 and I'm in the fire.
Yeah.
And that's of you say 500 cities per of fire. And the rest of it. Who calibrated them from 0 to 15 years at the top ceiling year 25? I don't think it is fair. There are the aggravating circumstances under which this crime was said to have been done. And reaching that far, with me, Akasoki, Aquako Francophobia, Sikafi, baby, and now Koya, no Koya, Kofono, baby, no Kofire, there was a threat, there was this, that Waka Professor Kano, there was a punishment, you didn't go that far. I believe that a lot of things had to do with who the woman was and what she was saying in the public domain at some point in time. Now, court of appeal, whether the lower court or a mistake, whether the judge was mistaken in applying the rules and applying the set of laws that he was supposed to apply. From what the guy is saying, but from what he's saying, that the lawyer on record is saying, I just say, and no matter judge, when taken into consideration, which he should have. I just say, all convicted man, all sentencing, no. One for Adrian, maybe so then Adrian Coswan was pronouncing the sentence. Definitely the judge in the higher court, he It's your travel no share adhering in a not apply the rules or the public policy come on. Obey who said judge said punishment is safe. So punishment is safe there. Obey reduce. Now it is at his discretion. It is our point now or no discretion. Let be open on the battle. Into the yagrada free. It could be anybody who has been punished the way the person should not have been punished. It's a matter of law and a matter of sentencing. So let me check. And for me, I don't see Agrada as a person there. I see the laws operation, the operation of the law, and maybe the court of first instance, judge didn't take certain things into consideration when he was pronouncing his punishment, and then the other judge in the other court took those things into consideration before he pronounced his appeal decision on that sentence. I don't have any problem. At the end of the day, your sentencing, there is sentencing, because this sentence is problematic. I don't think the woman has. There's so much aggravated situations pertaining at that time. My massacre, this kind of sentence is so draconian. Until me cancer, but I didn't push it forward. But that was my perception of the sentence anyway. I agree with the lawyer.
That's a brilliant submission. I'll come back to you right now. Just Mrs. Mami introduce you lawyer Adudako in the next 6 to 7 minutes now. On my preliminary submission. I mean court lawyer Mankwahinijan. So lawyer, I day na ma judges to me make a mistake because I don't get it. Ubia why law now obey a judge now what's ya kunyam na nipa mi rube kasem now obey taking the time actual judgment. There no mutimi mistake.
Yo, medals na mash bachia afefo nyina. Menya sure say necessarily a mistake. Emrano, yes, the law lies in the bosom of the judge. And the dream as a judge, exercise discretion or guided by the position of the law. And the way your submission now because you need a sentencing act, but there is an act that deals with our sentencing regime. Act 30. Criminal and Other Offences Procedure Act. No. And the Act 30 numa say offense we na so twini ni specify Act 29 na Criminal Offences Act 1960 no. On say if you case stealing na you case obi abokro no you be ma no 2 years and 3 years and 5 years na ebia act no section for na specify punishment no near one specify punishment no or direct to Act 30 oko Act 30 na no actually so say first degree felony you say second degree felony you say minimum you say maximum you say. I think the problem has been with senior lawyer for Mami Agrada Kaya, the information that was put out and the mistake that was made. Say, indicating say minimum sentence is 10 and a maximum no 25. The minimum sentence for offenses contrary to Section 131 of Act 29 and 10 years. 1312. And a year 10 to 25. I know or say so impersonate or man penny and I say abaimu nipa now dinidin a BB ebu nipa bifaswa. And no dear, yama between 10 to 25 years then was set minimum threshold and our maximum sentence. But Mami Agrada dear no not a year 0 to 25. Into the judge at the circuit court exercise discretion. But Nenfom so ne say osusu say 10 to 25. Me wa na betimi 0 to 25. And like I've had the benefit of the judgment. Me hear judgment na free high court the appellate court in this situation, High court no chair said there be 10 years enya sa na tie 0. Afin so amount involved nyina senior lawyers nyina yaken 500 cedis. Na perception ni mom ne say Yenim Mami Agrada in Fidi Atwam say yese wo yesika gari yese odobo sika obi se odi ni gold akoma no obi se odi na ade bi akoma no ntia na nkrofo fail say sa de no ene ye de court ama ye de maame ne kotu mu ne mo masema e court e de ne kotu mu ye se o se obey all night okuta sika oba be sika it would sika base ya onso benya sika sei. And those people that were called, you know, the rule of the game is evidence. It is a wo ba be di obetimi aka bibia ye kayi nyina be di nkomo oh where you say but it could do courtroom. You are subjected to the strict rules of evidence pursuant to the Evidence Act. I know natural say as I say we even how to take the evidence. And then I admissible, then admissible. Until no kasa be brainy bit in our bonting. Nemum ye back courtroom and then we streamline it. Yet the thing running in every hunafe yaba substance. It is substance in India and say also sorry. No so for your advert say I will buy the memo ska. Name Musu discover. Moko do sorry them one no. Usika de buy is cap to do say. What is cap to do buy and the assessor the man one farm. Sika send out the coy. I dance for a buy in Azika Mokano. 10 year can 500 cities are sent. 500 cities now do be cotum a year 15 years. Now to say you are killing a fly with a sledgehammer. I say adeɛ no ɛso so sen nipa na mmom because nipa no odin bi na yesu sɛ saa nipa no sɛ bi obu nkrɔfoɔ fa so na mmere bi a wɔtwam yɛ so esika guarantee no ne bɔ na ɛdɔɔso in the minds of people etin ke ɛhwehwɛ sɛ nkokom kramo ma biem but mmara ne nte saa ne nte mmara ne nte saa ne sɛ ɔkyena obenya asɛm afei wonya asɛm na wɔhwɛ lawyer ɔbɛboa wo ɔde bɛkɔ akɔgyina court na afei ɔde mmara na ɛyɛ adwuma ɛhɔnom na wobɛhu the benefit of the law. So I believe say the lawyer ne especially nikunu omo ya ade say they explored the avenue but that is not the end of the matter. Attorney General betime decide say bia o 1 year na e dey am me peneso enti emfa enko court of appeal we know say is your circuit court. And the jurisdiction of the High Court when it comes to criminal appeal, no, yes, I same for district court and circuit court. I bet me or High Court. Name say you can High Court now until I say out me cost. It is the same as Attorney General feels 1 year this one. Now Niagara for can say 1 year 20 or percent on twice. Or no, bet me appeal the decision of the High Court at the Court of Appeal. No, so I say you bet me answer sentence and don't forget say or call High Court no and go bet me up in 25 years. And go bet to 15, go bet to 10. Name lawyer for no so koyo majuma. As you say, Tokura net there, Jumana, Mamia, whatna case in this was circuit court, no, a year, and Santo Crony, they took advantage of it to the benefit of their client. And that's what we do as lawyers. Okay. Oh, no, she says our clients, no, uncle them, also see dear, or success, and say, Nipana, did not court, no, I did not go to know it may in a P. And no, our lawyer, no, also CD. And that's what you are trained to do. To prosecute now also the or client. So I believe the lawyer and then the family did very well in making sure that they took advantage of the position of the law to get it reduced. So Obi was sent for Frobi Tiama Ameno, efa money doubling, efa ne sensema betwem. Na so ajuobi day na say a person no dey dey quarter. And no a different matter. That person has the right to go and complain. But won't mean na sorry our year 190 so I was so no or Betty can when Yanchis can also discover say by in Tiafan Cotum Affable. And no dear, I'm running my own coin, sir.
All right, thank you very much, lawyer Jansuma Mrs. Let me introduce lawyer Mankwa Ohinijan. So, lawyer, Uti, the judge, you know, sorry, the lawyer, Edema, Madame Agrada, Nukuna no ne kana. What you say, the circuit court judge, you know, made a lot of mistakes. Any idea? Yemfane say. Mami Agrada, you're jailing in 15 years, no. The circuit court judge, you know, made a mistake. Okay, so let Mami Musao say Obi make mistake. Next year could jail me. Next and can be a mania appealer. I can mean that Kameko be a 15 years. But may I appeal no appeal court judge, you know, who say the bakuni a mistake. A basanes me try me sentence now. Find some 1 year we are. Or bet me a sue circuit court judge, no. Lawyer Jane. Hello there. Lawyer Hinijan. Okay. So let me give the same question to lawyer Joanna. So lawyer, to say that me busano. Lawyer Hinijan ba I will take his also on also so no submission on this. But catch say a baby be say no. lawyer ni hear that mistake, you know, say according to the report now, he appeals court judge, you know, and the ruling, you know, just said the first circuit court judge, you know, made a lot of mistakes. So obi making mistake not yet na kwakotu. Medical malpractice, you do obi etimi ja paso obi yam abro the surgery. Na nipa no apaso da kan yam no and all that. We charge the person for medical malpractice. Now, say eba BBC no a mami agrada nso betimi aka say papa wa tarnish me image. Wa ma ni pay di matem wa ma lose a lot of staff. SSM so me sue the court e betimi abasa.
Well, until I did 2 stages of conviction. Conviction here, okay, you go out for. I didn't know so we you know, the first we and a punishment you know so different. You convict you and suddenly have a sentence. And in this case, you know, obviously, the interpretation of the rules surrounding the relevant law 131 and setting a baseline at 10, but you know, clearly the interpretation of the law was wrong into your mistake. But that is to conviction, because that is to sentencing. Say you have a punishment, no. But the conviction they said into the okay say obet back or quarter or court said the sentence in one that's a sentence require reduce. And to conviction in as well appeal the yes okay man commit a crime beyond judge and I mistake no but what I hear the lawyer saying is that they tried to say on the question the whole of the conviction no and the sentence but they didn't succeed until the conviction was maintained, but it is the sentencing that was something was done about it. Well, I don't see how Agrada will succeed. Say, okay, she has been defamed by the fact, say, the sentence now has been reduced. The crime, you know, comes from, say, okay, you go out for, so what commit a crime? Punishment, you know, is separate. Some conservative punishment in India, you could do baby, or call back 10 years, and nearby years. Oh, punishment, you can came out 1 year, dear. No, because okay, my sentence, my court them. Every answer can be them in she will have a claim in court for the rest of the imprisonment now akona anka answer sanka okon. But conviction in there and establishes or committed crime and our committed crime or committed. Yes. Into a committed crime now unless said the lawyer Kasa Asana maybe Kasa Kasa said be attorney general Kasa okay or some person. And to office court of a high court decision, no, and yet the kind of decision no more president Johnson by appeal. Aqua court is almost appeal corner court is okay, yes, and the sentence that's by Biomedia, then it's a different ball game. But as it stands now, Nadia, a 2-stroke. First one here conviction, which she has been convicted of the crime. The second one here punishment. Punishment was excessive. Until the high court judge, you know, had to swab about 1 year. It will be very difficult for her to claim say she has been maligned and therefore she needs redress on that verdict.
So we don't have a precedent of that you convict you a bit wrongly than the person thinks that what destroy me image what character assassinating me why you normal be brilliant I lose a lot of stuff be an business crown many international mugus be partners be because of that they have cut the deals with many other staff no mean to me sue judge for making a sheer mistake.
And that's a judge you won't be sued. Judge in the court to now be sued a fencing punishment in the amount to be overcaught against the decision no not for work or for compensation for you being punished unlawfully. But I don't think we need this or that sort of a crowd because I didn't know that court in the car say high court friends appeal court in the car say punishment a conviction crowd you safe into a quash conviction and when you conviction if you hold here let's just one your body be and not to prison. I know dear because we go who fee because of their two baby so why born in here so many the hand of factors and you don't call you don't ban here costing here and you say who feel we no baby business when you don't maybe Obi it's and the other say yes, you're going to finti was say you're compensated for that. But conviction is still stands, which means a criminal abaho. And you do the oil and happy. Ultimately happy. So ultimately got you compensation for the fact that you committed a crime and you'll be found guilty. But punishment in those because actually they are. And a judge be by him so no punishment the same way they come and they are. Let's just say you are 7 now. And can say something 7. Which way you compensation.
Okay. All right, let me go to a lawyer, do that with the same question. Lawyer, you remember this boy called Kumi, aka Abu Treka? A couple of months ago, he was charged, say, oh yeah, cyber fraud, any idea, by saying, nay, at the court, a court, ejano. Na we sue in the interior ministry, SU na for SU attorney general, and we sue Yoko, say, omagunu hu fi so onya compensation of 10 million Ghana cedis. Now, a woman be okoye surgery, ewo Accra. Okoye surgery or Accra Rich Hospital, yenim haye, yenchemu haye. Na obukoja apaswade to the back and forth, we develop yarebi, no of people mutual no kwano, ni kunu ni na bushia for sue them any idea. So what I'm asking is a judge unim de na unim asem you have sentencing guidelines everything, but one share na uye mistake ya double checking what's a mistake some mistake now here no at the mark of 15 years supposedly say kebi amami agrada nye a year appeal and okotina mudia means that go 15 years in jail. But oya appeal no appeal court judge na who will say there was an inconsistency and mistake that the circuit court judge made. So in this case no me timi nkase papa why a mistake ma anya sad way what go be who fit no me do court. I was your submission on the same question.
No cray woman say or no judge our na asem so edino or the benefit of professional immunity. Say, Oka say, oh, call akusi judge na fe oh personalize judge no. Don't forget, say court no. Ebi a judge crocra what na sa asem no say no because our court no ni hobim. So it is not about the judge, it is about the court. It's the court that convicted you. And court unka say wundi fo, court to see wundi fo. Nemo maso training and net dorsal. I'm very particular with the word mistake. I ask a way appeal. I would say the judge erred in law or from so near the kindness of one. Ye nipa Emrano sono obia was any or kanya or one in Chirimunin in Tiasie. And the framers of the various statutes and your constitution no adjun one who say ye opin sa floodgate na afi will start personalizing courts no and attacking officers of the court omuyo medjuma judge nti asimu no say na mraneka emra krona yesese na sa kyerese se wo ni pakrona won ti ase a or the right of appeal enunti men na wo right so na yesu ye lawyer for ye nya adwuma nye enunti ni atete ye it is a yamount sentence. Now, so say, you don't go and attack the judge. You rather attack the sentence. Now, what Supreme Court impo etimit na sidi asem. What's the Supreme Court na court to bata record to nyina so. When a Chief Justice and Kasa tenase, it has same meeting about Chief Justice team. Na justice is a num atenase aka asem no. Say you can assembly we na want to once you have the right of a review of the decision of a Supreme Court, which is the superior court of judicature. So, and you will not be given that opportunity to attack the judge. In any case, but say abutrika dia kai. Ye nimseni ya police ne ye security agencies ni no mano mutimi ye adwuma bia sometimes ene emrano eboebra anaso man famra kwan so ebia warrant bi ohia for a search ebia arrest no ene sa no mani nyina amfa kwan papa so ebikura nipa no de not to custody more than 48 hours one for now court and all of that emrano ma kwan to send emrano ma abutrika kwan ne say you can sue these people but not the individuals. It's the office. The way the appeal was against the conviction and the sentencing and the whole thing. Court no. Court no say the conviction was proper. Name sentence no na the judge erred in law. And our man on the broso. We the matches amount. But the judge in a year impo was circuit court no. It's still within the remit of the law. Maximum year 25 years. In the end, so you mistake even with the minimum. Maximum need one track. Once he didn't go beyond the maximum, which is 25 years, it means that we are within the parameters of Act 30. I shall say second degree felony and a first degree felony and I say misdemeanor and I say any other offense and a sentence when you inform. I think so say the war ecotum wrongfully. Now a be later a partial conviction now. The position of the law is that you go to the Supreme Court and sue the state. Sue or minor, no minor man compensation. But we know it's not against the determination of the court at the High Court, which is an appellate court in this circumstance.
But immunity judges wouldn't also allow that judges to also personalize because would mean personalizing baby on Pewasama.
The moment you believe that the judge is personalizing a matter, you can even call for the judge to be changed in that particular case. Your cases are here.
No, deviate.
What about during the proceedings? During the proceedings, the judge will hide his bias. You wouldn't know. But during the ruling day, and I said the judgment day, no, that is where a beer or the personalization a be popping up. Nebia or the hito. The reason why I'm saying this is we are told this is a judge make this sentence. Ultimately, son will be right.
Or a fontus official, we in a juma.
Okay, that's fine. There was an issue be a case be about Kumasi. This guy a notorious pickpocket be no Kumasi. Na or pickpocketeer na ye de no court near jail ni bia 5 months near Giano. Any osako ye biem acha bia you 1 year 8 months no asako ye biem. Happened 3 times with the same judge. So one day the same judge who acquired us who biem hey monfano come 8 months. You get me. Then or judge in a cast MBTA a branch and says, sorry, a tier for near Shafon Fanchame, Shenanim Tantabi. And the guy also replied the judge and said, who's one him Tantabi? Because I cannot judge in a decline, I will a judgment in every Nessa. On to me, young some fan say, because of that, I reply need to know. A beyond the 8 months, no 10 months. Okay, now let's watch it this way. What about if the guy echo no cherry no sako? Now, same beside to no question the same judge.
No credit say if you have issues with a judge, send your medical can you can call for the matter to be taken from that judge.
Okay,
that is 1. 2, say you convict you bimpoa your previous crime our committee are convicted or no will play in the pre-sentencing hearing. No, you be say is this person known? By asking if this person no, you will say, "Oh, way we differ pen." Our case, ma'am, you had not prison and I say a sentence no, and I say a fine no, they are convicted of any offense. And now, you now go into determining the number of years that you put someone in jail. Okay. So, if you feel so, because nipa na hiding a bias, then it means it's a perception. Until say obey deliver the judgment, maybe in the judgment, you know, wakabi biwom. I had a similar matter. Kumasi, one of the courts, High Courts, one of the High Courts, where a judge, after delivering the judgment, a civil matter, a catcher microphone say, "Same way, we are few lose." Even after the judgment, which is unfair, which is prejudicial, which is not good for you, the judge, because when you were you must obey appeal, so be lose, so be winning and found. Immediately they reported the judge to the Chief Justice. Say there be asem na okan no not just or no we can form your opinion and men twice I mean a team for near benya clue who the judges into the infancy here. What I'm trying to say is that enormous is here people may have their biases, people may have their favorites, people may have their own issues with people, but anointing them random McQueen say you have the right of an appeal. It's every time be our feel set be bianco ye or mremuno. The judge is enjoying a certain immunity. That doesn't mean say oye perfect. Ya okrom ha na ensembe ba ma judges bi wo ha. Ye see bim koje mponche bim koje bibi ma ya punish wo mo okrom ha. Eyi or eji omo adwuma from nsem. So if you believe and you have evidence, emre adwuma no ntimi fa wa no keke. Ntimi fa feelings keke. Yeah, lawyers ye tin sem wo ha client bit bi abeka bibi atro and judge no ese ko be kwa na no kreba pray nim. And I said, I'm trained a trainer, sir. It's so deep the next year. Well, chastise somebody unnecessarily. But now, the end of the day, no, or yen juma. It's here the funny say, Obi a juma mrakwan. So, name so system ran one fine year juma.
Okay, lawyer Joanna, can you mute your set for me? Me call lawyer Joanna Hosisia. But per the old canon, my musa assassin, we say, your mammy, I could say, well, that Luma, the wife, Eddie Assam Kodan Court, Kumasi High Court. Now, ye cross-examine DW1, defense witness 1. The day near cross-examine in Vienna. Defense witness 1, Nankasinum, Asama Walker, which is on record as on audio. And Walker say, Tamana, ye di ye cross-examine ye the session of the day no. Ebi ye court ye na sorry no. Judge no e frɛ no che the chocolate. Owie no saka che ne say why ya de pa wasem sisusu pa. Young father says that it happened at the blind side of the plaintiff and the judges sorry the lawyers ne san call for. Tamana abranche ne be kai na asam ne ba abonte no. E ba say no a me sam ye lawyer. And for the plaintiff, and I said the plaintiff no deal for the now. What should be the next step of them?
I don't know. I asem no waka. And afi ofo say ehwa dance here ho. Na sa asem no betimi approve ya. Obetimi report sa judge chrono ka sa asem no. Say all case obi ayade na asem sisi so na wasama ne chocolate. Ni amemi hu ne say betimi aba say e bia na nipa no all kasa or radio so na TV so no na o ka de atu ame a kire say ono ankasa no wa ya ade na judge crab na but we need the implications of sa ade na o kan ye no and I say o feel say sa ade ni na contribute to the decision of the court, which is the high court at the court of first instance. Now what you do is appeal.
I see.
And you know, say if you have a personal issue with a judge, be it bias, be it prejudice, and I say because that will sound prejudicial. Say, hey, asema yendi new year kwani yesu obi ayade. Na so obi ayade dia, na chese any asema no enko mame. But me my case, I'm a judge. I catch them say, counsel, I'm enjoying your cross examination. Many cross examination now we know. And so you course no, you is our case no. Yeah, we need. So the fact that be a judge no a pass that comment no. It could be just a passing commenter and you're serious. The fact that the judge said, I'm enjoying your cross-examination, you know, just say, I said, no be diamami.
But there's a difference between enjoying and commending somebody. It's like, why are dear pa? Hey, Charlie, they're not okay, they're not, at the power. Oh, where the power? But why are dear pa?
I will interpret it to be the same. You find so because or enjoy Madia Meya. I take it that Adena Meya so judge in any. You understand? But just that instance, you know, the kind of cross-examination, the kind of questions, and man a certain insight into the matter, and man your prowess and your intelligence and your level of questioning and understanding of the issues. But that does not necessarily mean say we case in a wood, you know,
okay.
It is a case, your cross-examination, and some now what can and say. Judge ni bidia mo before name sa dance here where chese ampa or kasa asem no na wa asem ne fa onu susu say anko yia you can make a case against the judge and then chief justice ne judicial committee no mo hwe sa no man so no general legal counsel ne penifo ehwe judge for adwuma nyina so no omo betra se no ma hwe no ma take a decision.
All right, thank you very much. The last round. Namasabo maybe call Joanna how judicial efficiency and access to justice. Can Ghana's proposed court reforms deliver timely justice? Afro barometer Abache say Oba Ghana has here about 85% of Ghanaians they don't trust our judicial system. So and no and come and igusu ayedi. Yesu mami agrada there as a steady case. Now let me go to lawyer Joanna. Now lawyer na me bisa lawyer Richard I say mami agrada and the lawyer and me bisa and say lawyer Osha mami 7 previous and who ne hinitra na and I say na or answer come but bisa the Afro barometer year by say about 85% of Ghanaians don't trust the judiciary. No? A dear now free say Amasadia Naba. A dear pa na Amasadia Naba. Who are Solea no court, who court to some yes, a judge be a competent, lawyer be a competent, judge be a new mistake that. But still, people don't have trust in our judicial service. So a dear now Amasadia Naba. I'll mute yourself for me now. Yeah, I'll mute it well for me. Safa and Sakana and Baye. It's okay, it's okay. Lea, what meeting? What's that meeting? Adaroma.
Asmaba.
Go ahead.
Yes, I say.
Yes, but we are live on DSTV. The whole world is watching you. Could it be possible for you to shake your heart, kakre because kakani who me. We want to feel the full construction of your face. Yeah, that's what I go ahead. Go ahead.
Well, the delays in cases, the trial of cases in the cases there court media will be able say it is unacceptable. Justice delayed is justice denied. And now, if Chrome as in so appeal as of right, we don't appeal. So okay, you get 7 the crew, that's 7 don't know appeal. Maybe so for the Obeko before a merit judge. No, I say as my appeal now, Kwakoyano. He didn't want to say Nimu and Sanya Makwamo appeal. But I say no, it's out of merit. Appeal the court of first instance. Now, Nipa Krona, the case he did now or appeal. The back no appeal. If you are not Sikakro, we need Sikakro, the better case in the Subium to and also manage to me a just seminal no because they saw quite appeal and Sunday with Timiaka Kunya justice and the other bit to those say, I told the beer. Maybe to say England say. Almost the BFS a judge and I misbehave. The misbehavior of a judge, has nothing to do with appeal. That's a judge Nankasan were misbehave. That's the misbehavior. Why ye be I think Emrano Mbedra. For example, with the assembly. No DNO. Presidents Nene Emrano Nina Kase and what Daniel Assembly could say. England say yeah they Nasa back to Chief Justice name. Now Chief Justice is because it is more administrative. So I feel say the way a papa did assembly and your cause on number apart from the fact that the client friend say nipa na wedi for the bit me appeal no. You bet you so either say be na tadia and I be and we be the system mu ha. I just say ntino and you may be to be sick. Obi how I started the case from a circuit court. Obi who bear 5 years, 6 years, not still assembly that so cost. Obi how I ba say, or person invest, or invest wakota asase, or person this see a jumebi and then the rest of it. Now he's kept in court for bear 7 years.
Yeah.
Every time you be the assembly, and then the second uncle the baby business in Granash. Obi how judge ni ruling no no. Which is the ruling in appeal back. The Supreme Court I bet me decision, the correct decision. And it may take a long time. Definitely, and the system a delay cases. And there's some judgments be a banusuno and be ultimate draho was steady at the end of presidents who what they have to baby said that. Ukwana judge a different decision. And they true. Papa. Now the only way I know can be checked, then they be kind say the misbehavior of the judge. I know any appeal courts. The skin of the judge, he has to justify the way he actually arrived at his decision.
Yes.
And where the 10 for judges from skewing the judgment to one side or the other side, which amount for complaining of say very, very much. It made me feel that one in the it's something that is happening that has to be done.
All right. Thank you very much. Yebeko, Mesa Baba Bebiso Assembly, fa Abamusu Edie, Ekekako na. How do we make sure say in Kofobenya trust? Mesa really that trust in the but Mamin ko do that on having the last bite on this. But lawyer, Mamin Kasadu answer ya call the trust no. How come that yetimiya law na a sentencing guideline etima 0 to 25%? 0 means that the second degree felony will be a committed crime. It is not an offense, a crime. Then if you say 0 to 25 means that the discretion of the law, no, judge in the say any mean jail because 0 means nothing. A better a criminal and offenses and other offenses act at me are prescribed that.
So from 1 to 25 near custodial sentence. A custodial sentence. It is a 1 year to 25 years. A custodial sentence. But the other bit, 0, say I see a fine, and I see a suspend the sentence. But
I said fine, yeah, and a common misdemeanor. Because fine,
and because the discretion of the judge, it's and I make say, your public policy, they can't a law na judge in the pronouncing in the punishment. Public policy. Just what is accepted. She said the agriculture says you own that jury system. Nipa 12 never trans no many lawyers. But how many pronounce whether the person is guilty or not guilty. So say judge in trans no share aggravated circumstance the way the crime was seemed to have been committed and the rest of it not feel say. There are no aggravating circumstances. A man at the end could do a certain level. Or exercising the discretion. And to me, sure say appeal court judge and a high court judge now or appeal no. Or exercising the discretion. Say, look, I don't think this crime, this conviction merits this kind of punishment. Intermediate matisu. So Attorney General Zone Prince on because I said Papa and correct into a court of appeal and Kasa. No, I'm dealing with it. But so there's always a way to do Supreme Court now could review and it just happen. The car outside of the jurisdiction or the car outside of the country. But that's what it means because because of 1 year. A custodial sentence and that's a suspended sentence.
All right, thank you very much. All right, Mami call lawyer Eduda Kono the last bite na yen fan ko the we na so lawyer Eduda Kono enkofo matese enkofo kase se bia obi anya asem for example obi say Mami Agrada issue yi e bia asem na ba waya appeal yes appeal no ye kwa yentimi mfa evidence fufo bia amba mehemu biem. She said, "Na me busa ne lawyer no. Sa de ne eye ne kre. Say ne kre dear party na ma e bia ye di asema. You wouldn't allow me to tender in a fresh evidence e bia betimi aneli nipa no pi say ama approve say ade na nipa ne ye ne bia me right."
No evidence. My name there are exceptions. It is exception no.
Why you don't meet here? Can start afresh for me.
Me say the position of the law ne say untimi mfa new evidence emma appeal because appeal ni a rehearing ni akoso de dan ye behwe nemum there are exceptions to it. Exception ne say e bia na evidence bia very material which was not available at the time of the court of first instance hearing no. Now what discovers that new evidence no. There is a way obe apply to the court to be able to tender that evidence no in, but the court discourages new evidence on appeal. No crane say appeal no nya oka nyina ne say ne ankoso yie e wo court na e wo form no e na ye nhwe ne mfa yie ntu yie na nya say ye di asem na wie na wo say anko yie ama no afi na akọ hwehwe evidence foforo e di aba be ka wa asem.
Oh I see.
Eno nti no those rules are there. On say, and I am lawyer for training, so many years, obeko school be brain, and law no kind of back act back one way, obey from so. As I said, o combine emrani be brain, into a case back one case, say, district court and a circuit court in a one, high court in a one, you was our court new rules for her. Apart from the rules, your rules of evidence. Apart from rules of evidence, your rules of interpretation. Apart from rules of interpretation, there are so many. If you are substantive law now, what can one seminar? It be a road traffic offense. It is also called a road traffic regulations. You know, say DNA a DNA Evidence Act, a DNA Criminal Offences Act, a DNA Criminal Offences Procedure. What can you know? Boom. And now the idea of 70 in fact. I'm Rabba Copen Castle, you say, appeal don't mean for dancing, be a maintenance one. There are exceptions to it, but there are exceptions, there are thresholds you have to meet to satisfy the court as to why there fresh evidence, as you to Nana Ubusa question be, Mr. Senior Joanna regarding a year 0, another 1 day to 25 years in prison, Meaning the reason for conviction, the cause of conviction, a chesa wono, watomra, ememre bow for. Conviction alone is an indictment on you. It was a apply for visa. And now copy position B. I contested for parliamentary seats. May fill me form so no. Yebusa baby say, have you ever been convicted of any criminal offense in this jurisdiction? Have you been convicted elsewhere? Have you been paroled? And I say, have you been given pardon in a matter that you were convicted and then a 10 years, a 5? So conviction that was on Ankasano. I say o record. I face Rabayan San, I hope you have the horse was any power. Or Chinawunya Sanfofro, near Duko Jinakota, near Busasa, is this person known? Because yes. In the year 2024, 2025, this person was convicted of this offense. Ebia now called prison 1 day. Ebia now called a sentence and just fine. But you have been convicted of a criminal offense. And punishment, not necessarily so didn't panic prison. Where Okonsawem, Oko other prisons, and Kafomone other places are. Meaning, prison is the last place you would ever wish for any human being.
Yeah.
Tiny pan saying going to prison is the last thing you would ever wish for any person. So if there's any way we can punish that person other than prisoner, and there are a lot of advocacy for non-custodial sentences. And the interest of the state is not necessarily to put people behind bars and in jail. The interest of the state is for people to comply with the provisions of the law. So that we are all law-abiding citizens.
All right.
And we should be pro law-abiding than be more interested in throwing people in jail. And nipa na edo mu go to prison no, omo ye nkrofo maame mo, omo ye nkrofo papa mo, ebi mu ye breadwinners, ebi mu ye empanifo bia, so ma an opportunity a enanti ensesan bi ba ya, anko betimi abobra papa bi to contribute to our economy. And the interest should not necessarily be putting people behind the bars and behind prison walls. That will assume can be there. So if there are so many other ways that conviction on your head alone will deny you of a lot of opportunities.
I see.
A lot of opportunities. I know enti mami agada and nyame adom say ebiacha March April ngozi be June dey o dey abro so cry by July no
I say March 3.
I mean so you use prison years and any days in calculate here ebia by March obetimi apie yemfa ne say wapie mpo a she's an ex-convict. She's been convicted of the offense of defrauding by false pretense. Ochina okope position bia wo wiase bia that one will come at play. I be affecting. So Ochina also contest the election as a member of parliament. She is not qualified. Ochina also be minister of state. Sam random man kwine. So utimi buni pafa so ebia na 1 city. So you do betum 1 day, you do betum 2 days, you do betum 1 year, you do betum 5 years. The number of years in the aggravated nature of the offense. enti no obi ko wi ade na so wa amfa tuo ankosi nipa so etimi ma ne 3 years 2 years 1 year 6 months 3 days na mom so tuo dia na ye ma 10 to 15 to 25 years because what you know maybe a procedure the circumstances to take the decision.
Lawyer ye ko but mami say we answer my call Joanna hona ya ko mam we de mesro me di hyem keke insert waka asem na atwema dwede advice na me busa say court of appeal untimi mfa fresh evidence bi amba me rem wo say na wo kasa unless what.
And so there are exceptions to that rule. Exception is said would discover new evidence which was not available to you at the time of the court of first instance in a hearing. Yeah, cast seminal lower court no. It ever say a seminal circuit court and a high court. Yeah, cast seminal. So dancing, there's no way that a dance and evidence would have been available to you. You only discovered it after the court had taken its decision by way of judgment. And into what appeal you are then impressing upon the court. Madam Roma, adiwe na makohu. Sadiwe, there is no way ankamenya. In fact, asem ye diwe ya ansana eba ama ye hu se dance ye bi say wo ho. Eti Mr. Madam Roma monye sa dance ye no. Na mo fa nhwe se ebetimi asesa asem na esi ye na na. Eno no nya de etaisi because who opens our flag gate now and for Becca chose that document we cannot be new after menya it should be so convincing say at the time of the hearing you did not have that information you did not have that evidence.
Okay, so in this case Oshe Mami Akosia Sewa and a judge in her lordship Dorinda I reference to Kumasi High Court and no Odobro Nimu issue ya you say se Mamini ya appealer na say ebi at that time na omo high court no the original marriage certificate no omo tender year say enya papa no so oka say me kwa kofa ebi at the real one na ba eno no court na premier function na say be ka say that time no na enya available eno no
minim the nature of the appeal so many generic yemfa ne say wo ka certificate ho asem marriage certificate afebe na aware ye ebia me ware 2018 it ware 2018 na say case abaso 2024 adenti na wo pese o kire me say asat 2024 na 2025 na 2026 abe case no wa dia na wo as at the time when you farmer nothing now there but this is not a fresh evidence. I'm not prejudicing what happened over there because I don't even know the nature of the appeal whether or not there's even an appeal but what I'm saying is generally if it's a document me fan say me say my worry ya court na me trust my worry me marriage certificate me worry after 2018 there's me go for me marriage certificate mra na afi me ntimi afa sa marriage certificate na otena judgment bia ba na tia so wo kwa wo marry na ade na obitu futu go court and it edi asem na tiawa dem say makai na me document na me evidence no marriage certificate na da ba bia fe na makohwe na me ho a na chese wan kasa wo de wa asem ba court na wo bo because to say wari asem de ebeka edi ebeka wari asem de a bibia e kire se wo de wa wari bia na se wo de ba edi se me ko fida ko me se ma wari a se me de ho adanse ye ba e kire se ma wari enya afa ya ka asem awie awari a me wari in 2018 in 2019 no afa na me kofa ho krata ba this is something that should have been available to you unless you give compelling reasons which is very difficult to satisfy any appellate court say me the evidence for but now you are taking the other person one by surprise then you are not being fair with that person because you are be the asem ye nyina ya kan ye di na also won tiase ti won tiase a fa ko ne ba necessary tade no etina no so wa anya wo due diligence na wo information wo hia wa fa ankwa na mom ye fa ne say nkrata for the example case ya ma yi me can say yes time case because we are all following say yes document be or by yes some family book or something and if that family book you have to go through authentication and all of that be authentication na be a court of first instance na nyantum now feel it to say emremu you are right as I say, a G2 money and now tread the infractions of the law in terms of the admissibility of evidence, pursuant to the Evidence Act. Now, what say when the session judge and 1 year, so the judge erred in law by not admitting this evidence. Then the court can look at it and say that okay, it's a senka emrano or fase name amfa into any diamond. Because sanka judge ne fa kwan we so anka wo be timi esosidi na abesesa court na wase no a decision na mom say wo kofa bi before fraba it's difficult for any court to accept unless you prove beyond we say ampa ade ne ni ho.
Lawyer Adudako Esquire. Oh goodness. Law Obiama message will say in fact you are the definition of the law. So thank you very much, lawyer.
All right. So